Please.
Thank you, Judge. All United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Number 20-5158, National Council for Adoption, Appellant versus Antony J. Blinken in his official capacity as U.S. Secretary of State et al. Mr. Hay for the appellant, Ms. Lopez for the appellees.
Morning.
Morning, Your Honor.
You may proceed.
May it please the court, Daniel Hay for the appellant, National Council for Adoption. In this litigation, NCFA challenges on behalf of its members agency guidance that impose new obligations, requirements, prohibitions, and compliance requirements on all accredited adoption service providers without notice and comment and without fully considering the far-reaching and harmful consequences of the rule it adopted. The threshold question in this appeal is whether an association of the very adoption service providers being regulated has standing to challenge that regulation. Under this court's precedent, the answer is plainly yes. NCFA standing is self-evident because its members are the object of the rule. And even if it weren't self-evident, or even if there's some question about who the object of the rule is, NCFA amply demonstrated how this rule harmed its members and subjects them to sanctions for engaging in longstanding, common, and beneficial adoption practices. In addition, and for many of the same reasons that NCFA has standing, the rule is also invalid.
On the standing point, Mr. Hay, I think the question is whether the declarations are sufficiently specific in establishing that these agencies engage in the precise banned types of practices. Can you identify where you would say there's the most specific identification of recency, of actual sort of frequency of these cases? There's a lot of quite on point, but also very general statements in the declarations.
Certainly, and it might be helpful to look at each of the different prohibitions separately. So first, there's a prohibition on what we've called pre-eligibility soft referrals, which is any discussion of a child, even anonymously, before that child has been deemed eligible for intercountry adoption by his or her country of origin. As our declarant and as the record makes clear, this creates a catch-22 in countries like Taiwan, the United Kingdom, Uganda, Nigeria, and Pakistan, where eligibility is not determined until an adoptive family or parent has been identified and is pretty far along in the adoption process. As far as specific references, NCFA member Mary Mu at J150 talks about in Taiwan that the country, that there is no documentation that indicates children are eligible for adoption until after a parent has been identified. Similarly, in their declarations, Lucy Armistead and Robin Sizemore at J13 and 33 respectively talk about their agency's practices in non-Hague countries where children are not made eligible for adoption until after an adoptive family is in the process. Both of these members, and in particular Ms. Sizemore, emphasize their work in these types of soft referrals and say that they have not been, engaged in these referrals prior to the rule going into effect, and they have ceased doing it and would resume doing so were the rule vacated. The other
in the Armistead declaration, you're looking at which particular paragraph that you think is most most specific and on point in describing the organization's involvement in this kind of pre-eligibility referral?
Sure. So I think 6 and 7 of the Sizemore Declaration is where she speaks most clearly to it. When she talks about what prohibition she's referring to, she only mentions the prohibition on pre-eligibility soft referrals. She says that her agency would ethically and transparently use these soft referrals prior to the rule going into effect and would be vacated.
So I'm just trying to really develop what I think the district court was concerned about. And I know in part, and maybe less with the pre-eligibility than with the match part, it was concerned that the rule didn't even apply, by its sort of more by its logic. I think the that argument is hard to see preventing standing on the pre-eligibility practice. But here, for example, in the paragraph you point to, it's still pretty general. You know, prior to February 13th, 2018, ABI occasionally would make, ABI would consider, ABI would perform. And, you know, it's very general. We don't know, you know, a decade prior. We don't know how frequently. It's just, you know, when we have standing analysis that is, you know, requires it be imminent, and I'm just, you know, trying to really pin down what your best case is for the concreteness and the actually impending nature of the injury that's identified in these declarations.
Certainly, and you know, there's a bit of a challenge because there's confidentiality concerns about discussing specific closed adoptions, and it's impossible to predict what adoptions may come in. These are, as Ms. Sizemore mentioned, these are primarily non-Hague countries, and adoptions in countries that are not signatories to the Hague tend to be more unpredictable, and every adoption truly is different because you don't have a governing international system. What might help here also is the supplemental declaration of Dr. Daniel Nierbas at JA 275, where he talks about his agency's work and consistent work in Uganda and Nigeria, and how those countries do not make eligibility determinations, not just prior to a family being identified, but a family actually goes to the country, meets the child, cares for the child, and then after some period that could be as long as a year, goes to court, and the court makes an eligibility determination and approves the child for adoption. And so there's a good deal of specificity in Dr. Nierbas's declaration about those two countries in particular and their their specific requirements for eligibility. As for the other prohibition on holding, we've mentioned in our brief that the declaration of Ms. Perelstein at JA31 gives the clearest statement of harm, where she says that since the rule went into effect, families have come to her agency who want to adopt a specific child and can't, because she can't give some assurance that the specific child of interest would be available for them to adopt at the end of their home study. The district court found this to be too vague because Ms. Perelstein didn't explain what she meant by some assurance, but she did. She said some assurance the child would be available. I think on its face, this describes a hold, and certainly read in the light most favorable to NCFA and in favor of standing, this describes a hold. But if there were any question, Ms. Perelstein submitted a supplemental declaration saying that she was in fact talking about a hold, and that arguments about the scope of the rule, quote, have no bearing on her testimony. That's at JA 278, paragraph 4. So I think that shows that this is a practice that our members are engaging in particular in China. And this is, I think you asked a question about frequency. It's hard to gauge specifically frequency, but what I can say is that soft referrals are used overwhelmingly in special needs adoptions, where children need oftentimes specific advocacy to find families who are willing and equipped to take on the challenges of caring for a child with severe medical or developmental needs, or taking on a child who is near the age of leaving the foster care system in his or her country. And these adoptions often, in fact, Hague's Guide to Good Practice document recommends that agencies should what's called in adoption terminology, reverse the flow, meaning identify a child and advocate for the child to try and find a family, and then begin the home study process. Because when you are advocating for children, it's oftentimes the best approach to look for families who may have experience with a special need, have a specific moral or religious calling to care for children who have special needs. And these people may not be actively looking for an adoption and may not have started the home study process.
I guess one of the questions is, why would one not be able, well, you can line up and do the home study for such a family, but your point is that they might be willing, faced with an individual child, in a way that they wouldn't be willing to be open to being considered more generally as an adoptive family?
Certainly. So imagine a case where a family has a child with, let's say, a bleeding disorder, and is interested in adopting another child with the same condition and finds out there's a child in a foreign country who has a disorder and needs care, and that family goes to an adoption agency and says, we want to adopt this child because this is the same condition that we're experienced with. We think it would be great to have siblings who have the same condition. And if the adoption agency says, okay, we're going to put you through a process that costs thousands or tens of thousands of dollars. It's invasive. We're going to go through your finances, go through your criminal background checks, talk to your employers and your friends and your family, inspect every corner of your house. At the end of this long, invasive, and expensive process, maybe you can adopt a child that you came to us for, or maybe you'll adopt some kid who has a different condition or no condition at all. A lot of families, particularly families who are of modest means, aren't able to make that commitment. There are families who make the decision to expand their family through adoption, go through the home study, and then look for the child or children that will add to their family. But that's not the way that every adoption starts, and it's oftentimes not the way adoptions of kids with special needs begins, which is exactly why countries like China have created special programs that allow these pre-approvals to occur to allow.
I'm sorry to interrupt, but how would someone learn about that child if they hadn't been approved? If the child hadn't been approved?
About if the child hadn't been approved, you're saying?
Yeah.
So yeah, going back to
I
pre-eligibility.
mean, I understand, right, that there are these two, and you were talking about the when the family hasn't yet been cleared.
Certainly, and this may be helpful clarification. So when we're talking about eligibility, we're talking specifically about the regulatory eligibility for intercountry adoption, and this is either a judicial or administrative process in every country determining not just that the child is adoptable, meaning the parents are dead or no longer competent, but also that intercountry adoption in particular is in that specific child's best interest, which requires a determination that they're not likely to find an adoptive family within the country of origin. So in many countries, Ms. Mu talks about in Taiwan in particular, they make a preliminary determination that the child is adoptable, and that allows agencies to begin advocating. But the actual determination that they're eligible for intercountry adoption isn't made until the end. And of note, this is actually what's common in the United States in foster care adoption. When a child is committed to the care of foster care, parental rights aren't terminated, because the hope is that the parent who may be incarcerated or in some situation where he or she can't care for the child, the hope is that they will get to a point where they can be reunited with their child. If that doesn't happen and the courts determine that adoption is in the child's best interest, then at the very conclusion, the court makes an eligibility determination, severs parental rights, and transfers rights to the new parent. So it's very common to separate this initial adoptability decision from the actual eligibility for intercountry adoption. And in addition to the
Mr. Hay, you described the process for a home study as long, invasive, and expensive. Can you expand on that a little bit? How many hours would you estimate an adopted family has to spend on this process before the home study is completed?
Certainly. So there's education requirements that I believe are a minimum of 20 hours, and that's just classroom time. There's also homework and additional readings. A lot of agencies will have supplemental requirements about specific countries or specific needs. And then that's part of the home study. In addition, there is multiple meetings with social work. I believe it's 3 meetings. You have to provide a extensive binder of documentation of every legal birth certificates that have been verified and background check from every country that has been, every state where you've lived. You also have to write statements about yourself, your family, answer numerous questions. So I'm not sure the exact requirement, Your Honor. I'd probably guess, well over 50, possibly up to 100 hours. I think the Center for Adoption Policy amicus brief mentions that the average cost for a home study is around $7,000 or $8,000. It can often be much more, particularly for families who have moved around a lot and have to do more state checks, or for more intensive special needs adoptions where there's specific training or consultations with doctors.
That's helpful. And then just in terms of how a hold works, my impression from the record and from the briefing is that the adoption agency will do one of two things, or maybe both, and you tell me which of these they do. One is, once they put a hold on a child, they no longer tell other prospective adoptive parents that that child is available, or they no longer let other adoption agencies know about that child. Is it one of those or both of those?
I think it's both of those, and part of it will depend on what the country's requirements are. What Richard Klarberg explains in his amicus brief is that a match and a hold are really two sides of the same coin, where an adoption agency will make a match. And if the foreign country approves a hold, then the foreign country will no longer make that child available to other adoptive families not to go forward with the adoption, or the hold period expires. I think in particular, if you look at J151, I think this is also an email from Ms. Mraz, who's an NCFA member, who talks about how when a match is made, the country will no longer make the file available to other families. China in particular, a representative of the Chinese Child Welfare Agency at J165 talks about locking files. So it really depends on what the foreign country will do. But yes, once the agency makes a preliminary match, a soft referral, they will stop seeking other families, because it doesn't make sense to begin recruiting more families just to tell them somebody else is ahead of you in line.
Let me go.
Go ahead.
I was going to change topics, so
I was just going to say ask that. I thought the target of the hold rule was more when an agency is holding, contrary to the ability of the foreign country to make a sooner match, for example, or make the file available to other potential agencies or parents. So you describe, the foreign country approving a hold, and I didn't see that as the principal target of the rule, actually.
So what the rule says is that this guidance applies regardless of the actions of the foreign country. And in fact, at the State Department, after briefing was completed in December of 2019, had to issue a clarification recognizing that its initial guidance described a broader range of conduct than it intended, and said that participation in a program approved by a foreign country does not guarantee that you are complying here. So it's a baseline requirement. You have to comply with what the foreign country requires. But in addition, it goes further and says you can't do anything to discourage or dissuade another family or another agency from adopting. And that's very broad terminology that the state hasn't explained how far it goes. It's telling people, we have a family who has their heart really set on this kid and is far along in the process. That would be discouraging to me. If I was a second family, I would feel bad about going forward and possibly upsetting that match. State has also said there are limitations on what we can say to foreign countries, what we can advocate for in those countries. And maybe terminologically, the idea of a agency making a hold doesn't make any sense in this context, because it's foreign countries who determine whether to accept a match, foreign countries who determine whether they will allow a file to be held for a child.
Ultimately, but an agency can, as a practical matter, control information, right?
I don't believe so, because a agency can always go to the foreign country and say, we're interested in this child. There's no, it's not as though files are unique. These are electronic files where if a country chooses to send it to one agency, they could also send it to another agency. I think the real backdrop here is that foreign countries, and China in particular, have found it effective to assign files to specific agencies, so that one agency is putting all their weight behind advocating for a child, rather than having agencies recruiting multiple families, having multiple families invested in one child. It makes much more sense for China, which has an interest in making sure all of its children are adopted, to spread out the work and make sure every child is being advocated for. And the effects of this rule, as explained by our amici and in our brief, have been unfortunately devastating for intercountry adoption, in China in particular. At footnote 12 of our brief, we note that in the first fiscal year this rule went into effect, adoptions from China alone dropped 57%. And that is the country with which we do the most adoptions every single year, and the country that our members, in particular Ms. Perelstein, have said has been the most affected by this, because there has been a longstanding and very successful program to advocate for special needs kids. And agencies are now limited in their ability to fully participate.
Where's the 57% figure? You mentioned, I think, but I
Yeah,
missed.
that's a footnote 12 of our opening brief, and it's
Mhm.
from the State Department puts out annual reports about adoptions, and we compared the fiscal year prior to the rule going into effect and the fiscal year after. And this was all pre-COVID, which has obviously had another effect on adoption. But these numbers, I think, stopped in September of 2019.
You
Mr.
also
Hay, can
had
we go? Oh, no, please, Judge Pillard.
you also had mentioned that as harm, the compliance obligations, maintaining documentation, but that seems that the guidance is pretty clear that it's only encouraging the maintaining of documentation. That alone wouldn't support standing if we didn't have the effect directly on the practices of the agencies, would we?
I'm not sure that's true. I mean, it's encouraged in the same way the IRS encourages me to hold on to my tax returns, but it's not just in the guidance that these compliance obligations come in. Agencies have the burden to show that they are eligible for accreditation. And if there is a question, a complaint, a spot check by the accrediting entity, they have the burden to show that they are complying with the rule. The State Department has entirely delegated sole authority for accreditation adverse action to a third-party accrediting entity. It's currently an entity called IAME. And that the only control the State Department exercises is through a regulation and contract that says the accrediting entity has to follow guidance as though it were equal to a legislative rule. That we cite the specific Federal Register provision for the contract in our brief. And in addition, the SALT referral rule purports to interpret a provision that state itself has deemed a mandatory requirement, meaning that if an agency doesn't meet 96.35 best interest, it cannot be accredited, and the accrediting entity has no discretion. At 22 CFR 96.27a, it must deny accreditation to an agency that seeks accreditation and violates the SALT referral rule. And 22 CFR 96.71b, if it finds an accrediting entity has violated the SALT referral rule, it must take adverse action. And what the adoption attorney's amicus brief explains at page 13 is that the accrediting entity is currently making demands of agencies to show specifically when they began or to document that they're complying with the rule. So these compliance obligations run to every agency. They have to show not only that they follow in every instance the rule and can lose their accreditation if they don't. They also have to show that their policies comply with it, and that's exactly what Sarah Mraz talks about at JA 255 and 257, where she shows she's changed her policies to comply with the SALT referral rule.
Mr. Hay, we haven't talked about whether the district court erred in striking the supplemental declarations. My first question is, would you agree that motions to strike only apply to pleadings and that these declarations weren't pleadings?
Certainly, Your Honor. I know the motion to strike has been used oftentimes for evidentiary purposes, but this wasn't a 12F motion to strike. That's correct.
This may or may not go to whether it was appropriate to strike them or not, or why didn't you file them earlier?
So we didn't file them earlier for a few reasons. The first is that we reasonably believe that our standing was both self-evident and established based on the initial declarations. They were filed in response to something state said in its opposition to our motion for summary judgment, where they said NCFA still has not identified a member who has engaged or would engage in the practice. That was an incorrect statement. We believe that it misinterpreted our declarations, but rather than fight about what the declarations mean and what they really meant to say, we let the declarants speak for themselves. We identified.
Hadn't they first said that in their motion to dismiss?
No, because we hadn't submitted the declarations yet. And in their motion for summary judgment, they simply reincorporated the motion to dismiss briefing.
You're saying that as soon as State Department made the argument that your initial declarations were insufficient to support standing, at your very next filing, you submitted these supplemental declarations?
No, there was a reply brief to the motion to dismiss, and we didn't file any supplemental declarations with our motion for summary judgment, which would have been the next filing. And the reason we didn't is we believe that our standing was self-evident and clearly established. When it became clear later in briefing that there was this terminological dispute about how far the rule reached, we thought it was better, rather than fight over what these people meant, to let those people speak for themselves. And I think of particular import here is the State Department's December 2019 clarification, which occurred 8 months after these declarations were filed, long after, I believe, 5 or 6 months after the close of briefing in the district court, where they admitted that the initial statements on their website and statements to agencies that all soft referrals are prohibited goes too far. So I think if the State Department itself struggles to articulate what it means, if senior state officials are misdescribing the rule to NCFA members,
Yeah, no,
assuming the members
that's
work.
helpful. That sounds right. That's helpful. I've,
No, go ahead.
I was going to change the topic again. So if you have a follow-up, Judge.
On the standing and on the support for it, the district judge held that under 12B1, so as I take it, as a matter of pleading or motion to dismiss, that there's no standing. If we could, I suppose, reverse and remand on that, but you have urged us, relying on Mendoza, to go ahead, if we were to find standing, and decide the notice and comment legislative rule claim. Can we do that the record supports standing? And is there any limitation on our ability to do that here?
I think that if the decree or the judgment was to enter judgment, then yes, we'd have to meet the summary judgment standard. But I do believe that since we have relied on the administrative record and submitted declarations, we have gone beyond the pleadings. We're not simply, as Lujan talks about, making averments of our standing, but we have shown specific evidence that there's a dispute about what it means, but there's no dispute that what our declarants have said is true. I think that is a sufficient basis to find, as a matter of summary judgment, that we have standing. And I think in particular, even though the district court ruled on 12B1 grounds, the consideration of facts and not just accepting the allegations as true, I think did go to a summary judgment type analysis. That's why we don't really fight about whether this is 12B1 or Rule 5 summary judgment. So we think that the record is clear for that. So we do think that it would make sense to reverse on standing, and then also to go forward as the court did in Mendoza to decide the merits, because this is a pure legal question. There's no special competency of the district court. And, not unlike in Mendoza, there's real harm here, as we've talked about, that the rule has been in effect for 3 years as of this past Tuesday. And during that time, families who would have children have had to wait longer or not even begin the process, and children who would be in loving families are remaining in orphanages longer or permanently because of the rule.
So ordinarily, if a district judge is going to convert a motion to dismiss to a motion for summary judgment, they have to give notice. And I take it your position here would be, well, district judge didn't say a lot about it, but in finding that it was prejudicial for the second declarations to be included with the reply, and I can ask this of Ms. Lopez, but presumably their potential prejudice would be if state wanted to put in contrary evidence. I mean, on a summary judgment sequence, that would be one of the things one would suspect would be a source of prejudice. And why isn't that a problem for the proposal that we go ahead on summary judgment here?
I think it's a problem because state also cross-moved for summary judgment, and in its summary judgment brief said it was entitled to judgment based on standing. And so if state wanted to put on contrary evidence, it could have done so in the summary judgment brief, and it for whatever reason, I'm not sure why, it chose not to do so.
Mr. Hay, did you file a statement of material facts not in dispute?
This wasn't required under the local rule because it's an APA challenge. There's a local rule in the district court that's only required for non-APA cases. So no, we did not. Even for standing? Is that rule? Does the rule also apply to standing issues? I believe it does. I think it says it applies to, I believe it incorporates either the APA or actions against government agencies. That's my recollection, at least, of the local rule. It doesn't apply to standing.
Okay.
Sorry, go ahead, Your Honor.
I was just going to, well, actually, Judge Walker, you had said you had questions moving on from that. Why don't you go ahead?
I'm actually good. I appreciate it.
Okay. On the notice and comment claim, doesn't it just stem from a policy disagreement with the State Department on what's in the best interests of the child? And if so, how is that a legislative rule requiring notice and comment?
I don't believe it's a policy difference for a few reasons. One is that this is a statement that is binding in effect on every agency. And this court in Appalachian Power talked about guidance documents posted on websites that have the effect of legislative rule. If it's binding in the field, if agencies believe their permits will be declared invalid for noncompliance, if it's treated like a legislative rule. And all those are met here because the State Department has instructed its accrediting entity to enforce this rule to the letter in every enforcement action, and through regulation has deprived the accrediting entity of any discretion to reach a different conclusion, not to take adverse action, to grant accreditation notwithstanding any violation of the rule.
The fact that it's required, though, I mean, the best interest of the child standard is required. And if state were to articulate a specific rule, or a specific guidance that was mandatory, that no child should face a prospect of abuse in a placement, or no adoption should be unnecessarily delayed for, just unnecessarily delayed where the best interest could be met by more prompt action. Those would be more specific rules, but wouldn't they also just be policy interpretations, guidance, clarification of the best interest of the child standard, and not separately require notice and comment?
Sure. And 2 points in response to that quickly, Your Honor. First is that I think it may be theoretically possible that state could say, we have determined that this specific act is so harmful that it cannot be done in any adoption consistent with the best interest of the child. State didn't do that here. What they said, in fact, is that these are oftentimes harmful to children, which means that there are times when they are not harmful to children, that there are times where soft referrals increase the number of families willing to adopt or expedite the time where an adoption would be completed. Second, and I think this court's recent decision in Poet actually gives a nice comparison to the rule here. In Poet, what the court recognizes is that a interpretive rule must be fairly viewed as interpreting a statute or regulation. There is nothing interpretive at all about the soft deferral rule. It never cites, quotes, engages with any statute or regulation or the convention. In fact, the only point where it mentions regulations is at JA 62 in response to FAQ 1, where it says the rule is an interpretation of policies that are consistent with statutes and regulations. Not that it's interpreting the regulation themselves, but rather it's interpreting policies that it believes are consistent. What this court has said repeatedly is that consistency with the rule is not a hallmark of interpretation. Plenty of things could be consistent with the rule. When an agency is choosing amongst many different options on how best to exercise its delegated legislative authority, that is a legislative act. And what this court said also, and going back to comparison to Poet, the court there said it could hardly be clear the guidance there was interpretive in particular because it never deviated from the regulations text. Again, there is no engagement at all with the regulation here. And in fact,
you've already mentioned a few places where you characterize the agencies as treating the guidance as mandatory, having a binding legal effect. Some of the briefing talks about it that way, but where would you point me in the record to the best evidence that an accrediting entity is actually categorically bound to follow the guidance, as opposed to sort of prudentially likely because of their need to maintain accreditation?
Certainly. And so the administrative record here stopped, I think, the day after the FAQ was published. So we don't have any enforcement actions in there. And because enforcement actions are taken by a third party, they wouldn't even be in state's administrative adoption academy brief at page 13 says that the accrediting entity is enforcing this. There's also Mr. Klarberg's amicus brief talks about, I think it's at pages 20 and 21, and a case a few years ago involving Faith International Adoption, where his agency, the Council on Accreditation, was at the time the accrediting entity, and they believe that guidance state had issued was incorrect. And they told state this, and state said, regardless of what the guidance says, you have to enforce it, and as a result, you have to strip these agencies of accreditation. Those agencies went to court, they obtained a preliminary injunction. The court found they were likely to show that the guidance was in fact a legislative rule. But for those agencies, it was too late. Those agencies, I believe all three, or at least two of them, went out of business. We have a declaration from one of them, Ms. Alberts at ECF 24-2. It wasn't in the JA, but it's ECF 24-2, where her agency was forced to close because the State Department forced the accrediting entity to treat its guidance document, its unlawful guidance document, as a legislative rule and deny accreditation on that basis. So we think there is strong reason to suspect that the accrediting entity will do what is required to do and enforce these rules as though they were legislative. Just a final point in response to your question about how this is not just a policy disagreement, it can be a policy disagreement because it rewrites provisions of the legislative rules. In particular, it imposes timing requirements on when home studies have to be completed and when eligibility determinations have to be made that don't exist in legislative rules or the convention. And more directly, it redefines what best interest of children means. This is a very common term. It's probably the North Star to most areas of family law. And in all states, all countries under the convention, as the Center for Adoption Policy explains, this is a case-by-case, fact-dependent decision that looks to the child's needs and what would be in that child's best interest. The State Department expressly, in its notice of proposed rulemaking back in 2003, excuse me, chose to incorporate state law wherever possible, and in particular to adopt state law on best interests of children. This makes
all right. I mean, we've taken you well over your time, and I appreciate your responsiveness to our many questions. Judge,
I appreciate it very much, Ron.
Judge Walker, do you have additional questions for Mr. Hay?
No, thanks.
All right, thank you, and we will give you a brief rebuttal time. Ms. Lopez, good morning.
May it please the court, Carolyn Lopez on behalf of the government. I want to start out where the court did with really focusing on understanding, because there's still been a mischaracterization of what the conduct that's actually prohibited actually does. And so I think we're all on the same page, but I want to make sure, and I'm going to take each in turn, that narrowly all the guidance says with respect to children who have not even yet been deemed eligible for intercountry adoption is that it's inappropriate to refer those types of children to parents. And that's consistent with the State Department's prior debarment action at JA 117.
And Ms. Lopez, that's even if it's an unofficial match, correct? You're
correct. And the reason for that, and that's because, as the State Department described, it boggles the mind that you would need a specific regulation in this context in which for a child to sort of even come into this context, they have to be at least eligible for.
What do you say to the example of Taiwan, for example, which you know what I'm talking about?
Yes, that actually mischaracterizes what's going on in Taiwan. And I think it's really important to drill down into that, because that's actually a mistake made both in describing Ms. Mu's things, as we talk about in the brief, and also in some of the declarations that talk about the termination of parental rights. And so that there, the confusion there is that the distinction between the termination of parental rights, which in some countries doesn't happen until the end, and a determination that the child is actually eligible for inter-country adoption. And those are not coterminous. And we know those aren't coterminous from the articles of the convention themselves. So that's Article 4C recognizes that the termination of parental rights isn't always necessary for a child to be determined to be eligible, and also Articles 26 and 27 of the convention. And so when one looks at what Ms. Mu actually said, so this is at JA 138 and JA 150. At JA 138, she describes specifically Taiwan as a country where there are children who are, quote, legally eligible to be adopted. And so this State Department took her at her word that what she was talking about in Taiwan is children who have already been determined to be legally adopted. And then again at JA 150, she talks about how these are children that have already been registered in Taiwan, i.e. registered for adoption, intercountry adoption, and that a determination has been made by their orphanages.
Let me see if I'm following. Your position is that an adoption from Taiwan could work like this. The government of Taiwan declares a child eligible for adoption, even though the child has not been even informally, unofficially matched with an adoptive parent. Then the adoptive parent goes through then a match occurs, a hold, if you will, occurs, and then Taiwan's government says this child can do an intercountry adoption.
No, Your Honor, that's not what I mean at all. What I mean is that, and thank you for the opportunity to clarify that, a lot of this confusion arises, I think, because plaintiffs and
But,
plaintiffs.
don't tell me what they said. Just
Sure.
tell me
So-
how
so
an
if
adoption
you,
in Taiwan would work.
Sure. So an adoption in Taiwan works this way. Taiwan says this child is eligible for intercountry adoption. We're going to add them to our registry. The child is then eventually matched with a parent. As part of that sort of
held officially, like held.
Well, any holding, and any holding, as the guidance makes clear, that's done by the country of origin, so Taiwan, is fine. It's only when the adoption service provider is doing the holding instead in such a way that prevents other families from considering the family or Taiwan from making a different choice that it's a problem. So there could be a hold.
What if the agency does something that prompts Taiwan to hold the child? Is that allowed?
So as the December 2019 guidance made clear, the agency can continue to advocate for their family, but what they can't say is, Taiwan, you should adopt a proposition in which you always hold these children no matter what.
But they can go, I thought, I mean, he can speak for himself. I thought Judge Walker's question was, is it okay for the agency to request that the country government allow a hold?
It's okay.
In an individual case.
Sorry, so the 2019 guidance, December guidance, says it's okay for them to continue to advocate for their child, for their family that they're representing, and to say, we think that you should still pick our family over the other family. So that's a sort of specific thing. But what they can't do is say, we think you should always, no matter what, hold this file. And so, but I do just want to get back to sort of the distinction between I just want to make sure we're all on the same page about this distinction between the termination of parental rights and eligibility for intercountry adoption. And the reason that it makes sense for some countries to sort of separate that out is what they're doing is so the child is actually eligible for adoption. The second, the child, that intercountry adoption and not domestic adoption makes sense. And third, that if there are any remaining parents, and there would be with this termination of parental rights question, that there's been free and non-coercive descent. But what they might do is still want the child, where there are living parents, to have some sort of legal tie to those parents while the adoption is being made. And then also the Hague Convention recognizes that in some countries, there's not a termination of a total termination of parental rights, and there may be some sort of relationship thereafter. And so it's really comparing apples and oranges. And I do just want to emphasize again that Mary Moo, which is the one sort of record evidence that they provide, she herself says that Taiwan is talking about eligible children who have been registered. And at JA, I think it's either 263 or 265, after the May guidance is issued and after she's asked these questions, she says the State Department has answered all of her questions. And so,
Ms. Lopez, let me see if I've just followed you so far. I'm going to describe an adoption from Taiwan, and then I'm going to have two questions. The first question is, you did anything illegal? And the second question is, would Taiwan allow this adoption to happen in this sequence of events? So is it okay with state, and is it okay with Taiwan? And I'm going to tell you the sequence of events.
Sure.
Taiwan declares the child eligible for an intercountry adoption before the child has been even informally matched with any American parent. Then the adoption agency informally matches that child with an American family. And the adoption agency hopes that Taiwan will hold that child, but the American agency is not allowed to request that Taiwan holds the last of what's required in order to terminate parental rights and make the child completely 100% eligible for an adoption. And then at that point, the child goes to the American family.
Sorry,
would Taiwan allow that to happen? And would State Department allow that?
I actually can't get that much more into what Taiwan does and doesn't do outside of
It's
this particular record, but I can say that
right?
I can say that generally seems correct to me. And I do want to just clarify one thing. again, looking at Articles 26 and 27 of the Hague Convention, the termination of parental rights sometimes doesn't even happen until after the end of a final adoption. And so I do just, and this is really why it is apples and oranges. The thing that has to have been done is that the child has to actually have been deemed eligible for inter-country adoption. And the question of what happens with the termination of parental rights as a formal matter varies country by country. And as the one person who brought up Taiwan said, the State Department's guidance answered all of her questions. And then,
Okay, no, go ahead.
So that's sort of the eligibility piece. And then and I'm happy to sort of talk through any of the individual declarations on that, but I also wanted to make sure that we talked about the scope of the soft referrals to parents who haven't been.
Excuse me, what determines the child's eligibility if it's not dependent upon parental rights?
So a parent in an adoption, one can imagine that a parent could consent to the child being legally adopted by other parents, but might want some sort of and the Hague Convention itself clearly separates out those steps. So Article 4, which is the article that's all about how the state makes that eligibility determination, Article 4C says, including that parental consents have been made, including in countries where that will result in the termination of parental rights, that they've been appropriately apprised that that's one of the consequences.
Now, aside from the interaction of the child with the natural parents, what else is there to determine eligibility?
It's that they're eligible for adoption in the first place. So even domestically, that they're eligible for adoption, whether that's because their parents have died, their parents have.
What's the criteria for determining eligibility?
That's vested with the country of origin, and it's in their discretion to determine whether one of the factors have been made, which as we've been discussing, might be that the child's been abandoned, might be that the state has made a finding that the parents aren't competent to raise the child, might be that the parents that the child's parents are deceased. So that's a question of eligibility for adoption generally, or staying within their country of origin is in their best interest. And if there are surviving parents, that parental consent piece that we've been talking about.
You might have parental consent without having gone formally through a termination of parental rights. The parents are prepared to do it, but it just hasn't happened. And as you said, it can be useful to have a strand of parental right remaining as it's sort of like real, I mean, this is crass, but real estate, contract and closing, that there's a reason to have two different moments when everybody understands what the plan is, but it hasn't actually been effectuated.
And that's very country dependent, sort of whether termination of parental rights is sort of coterminous with that original decision or happens later at the process. And then if I might just, and none of the declarants here say that they've done that. So for example, Armistead, who's one of the declarants that they rely on, at paragraph 6 of her declaration, she actually specifically says that the types of soft referrals that her agency used to engage in were between adoptable children. Now, adoptable children, that's exactly that for a definition that adoptability has been determined. So she's not saying that she's matching children who aren't actually eligible.
I understand, Ms. Lopez, that there's been some kind of misunderstanding of the bar against holds, and that some of the declarants may have mistakenly read it as barring more than it does. But what about the Sizemore Declaration, which addresses only pre-eligibility adoptions, meaning where the family hasn't had the home study? And it seems like that's been more clearly understood. And why doesn't that declaration establish standing?
Sure. So on the Sizemore Declaration, particularly because we're talking about a motion we're at the summary judgment stage in terms of the record, she just hasn't done enough to link up her statement indicating that she understands that the guidance prohibits referring children who've not yet been deemed eligible to what she actually does. So the two types of things that she's talking about are special needs adoptions and kinship adoptions. And with respect to special needs adoptions, those are eligible children. They're not ineligible children. And she's talking about sort of recruitment, and the guidance talks about all sorts of things that you can do to recruit families in such situations, including photo listings, for example, of eligible children. And then the other thing she talks about is kinship adoption. And here again, it's a very conclusory, so we don't know if they're likely to do it again in sort of a clapper sense. And that's particularly underscored here where
I just want to interrupt you because there's an overall problem lurking in this case, and I don't think you've addressed it. You've done a fine job of picking apart the declarations, but the question is on, as you said, it's on summary judgment, and on summary judgment, the declarations and affidavits of the non-moving party have to be given credit and deference. You construe them in the light most favorable to the non-moving. And if we do that with each one of these matters that you're taking apart, and I think very artfully, you lose.
No, Your Honor, I don't think so, because even at the summary judgment stage, it remains their burden to show that they actually have standing. And while the court can sort of make
I'm not talking,
and does make,
pardon me, I'm not talking about bird declarations, and they have to be construed in favor of the non-moving party. That's just standard black letter law.
Absolutely, Your Honor. But what this court has also said in the standing context is at any stage, whether that's the pleading stage or the summary judgment stage, the court isn't to fill in logical gaps between what they have actually said in their declarations. And so what I'm in the State Department's view, they have left those gaps. And so we don't know.
Tell us more very precisely what you see as a gap. You said a few moments ago that you thought that the Sizemore Declaration hadn't done enough, even though she's correctly describing the practice. And when she talks about family recruitment, there's no question on that side of the equation about the hold and, when something is deemed to be an impermissible hold and when it's not. She's talking about, can we, it was the issue Mr. Hay was describing in some detail. Can we as an agency work with a family that is particularly motivated with respect to a particular child and make a permissible match, otherwise permissible, before that family has been deemed eligible?
And the answer to that is yes. I thought we were talking about sort of the part of Sizemore that goes to eligibility of children. So the guidance makes clear that if what she's talking about is matching an eligible child to a family that just hasn't undergone its suitability determination, it absolutely can do that, so long as it doesn't interfere with other families' ability to consider that child or interfere with the country of origin's ability to make a different choice. And the reason that I think she sort of does, I agree, seem to be talking about that at times is because when she's talking about recruitment, like again, recruitment of children with special needs are eligible children. And similarly, she sort of talks about the need to educate parents about specific children, which you would see with, again, eligible children. And then just very quickly with respect to the kinship adoptions, at question 4 of the May FAQs, the State Department clarified that, in fact, adoption service providers can accept applications from families who have pre-identified a child, including in relative situations consistent with incorporating the limitations in Article 29, expressly incorporating the interpretation in Article 29. And so because we don't know, she just says she has changed what they've done in kinship adoptions, but because the guidance allows them to still do things, and specifically has a question 4 about that, she would just have to give more details. We don't know, and even at sort of taking all inferences in her favor, she has to provide more explanation.
What would she have to say? I'm just really trying to understand, because obviously level of specificity is a spectrum. What about what she has said about pre-eligibility adoptions is inadequate? She does say in paragraph 8, as you noted, Hopscotch immediately ceased certain recruitment efforts to comply with the guidance, and have even limited our ability to complete kinship adoptions.
So she would have to explain how it limited her ability in kinship adoptions. So if, for example, it's just that they stopped accepting applications from kinship adoptions, that would be sort of a self-inflicted injury because Q4 tells them that they actually can do this. She'd have to actually say the reason it stopped kinship adoptions is because we were proceeding with kinship adoptions involving ineligible children. It's a pretty short sentence, and it's something that's entirely within their knowledge and not the State Department's knowledge in terms of what they actually do.
But as Judge Randolph was saying, it seems not at all counterintuitive that, starting with paragraph 6, she says, it's my understanding the State Department is taking the position that soft referral is unlawful when a child and prospective adoptive parents are unofficially matched before the child has been deemed by the foreign country eligible for adoption. And then she basically says, we've been doing that and we're good at it, and now we're not.
So I think the problem there is when she says it's piecing together different parts of her declaration. One is that she does understand correctly that the guidance does prohibit referring ineligible children. But then when she's talking about the types of practices that they engage in, she seems to be talking about the other type of soft referral, which is a soft referral of an eligible child to families that may not have completed their home study adoptions. And that's what we're talking about when we're talking about recruitment of children, that sort of those photo listings and the special needs programs, those are all eligible children. They're not ineligible children. And sort of, I agree, I think that the kinship adoption gets the closest, but even there, in light of question 4, I don't think she does enough to describe, sort of, even at summary judgment, sort of conclusory saying without any details how often what exactly you're doing when it's totally within your own knowledge is insufficient. But and that's our view of why the Sizemore Declaration is insufficient. If I might turn to, I'm happy to sort of, if I might turn to this sort of the other part of the conduct, because they have to show standing with respect to each part of the conduct to actually have standing to challenge the relevant portions of the guidance with respect to.
Well, they're challenging the guidance. I don't think they're challenging just certain sentences of it, right? And either injury on all of the pieces of the guidance address both practices. I'm not sure, because they're not separate claims, that you're actually right, that they would have to establish standing with respect to both facets of the guidance in order to say the guidance as a unit needs to be.
We think that they would. We agree that there are certainly parts of the guidance that speak to both types of soft referrals, but also that there are parts of the guidance. So, for example, whether or not a child is eligible in the first place has nothing to do with holds. So the part of the guidance that has to do with adoption service providers doing holds instead of the country of origins doing them just aren't implicated. That sort of part of the guidance isn't implicated at all by this eligibility question. So in our view, sort of anything in the guidance that's sort of fairly classified as, it obviously goes to sort of both types of narrow conduct, as long as they sort of show standing with respect to either, that's enough. But the parts of the guidance that really are discrete and come from discrete pre-existing obligations, they would need to show that somebody is actually doing that. And I did just, if I might, turn very briefly to just to make sure that we're all on the same page about what the guidance does and doesn't say with respect to parents who haven't completely undergone their home study evaluations, especially with respect to the program in China. That is not something new that's talked about in the December 2019 guidance, which I'm sort of surprised to hear plaintiffs say completely changed the game, because in their opening brief at page 13, note 3, they say the new guidance does not change the scope of the rule, and that's exactly the State Department's position. The district court held, as the district court correctly recognized, for example, at JA 92, note 4, and JA 286, the March and May guidance already made clear that this wasn't some sort of broad categorical ban, and instead with respect to this particular question, that it made clear that really what we're talking about, and I'm sorry if I sound a bit like a broken record, but I just want to make sure that we're all on the same page, that it's just about it's the difference between it being in the hands of the country of origin to make the decision to hold, or the adoption service provider sort of preventing other families from asking about that child, or interfering with those adoption service providers reaching out to the country of origin. And specifically with respect to the China program, as early as JA 59 through 60, which is that first March guidance, the guidance comprehensively discusses the China program and specifically says that it isn't saying anything about China's ability to hold that file. So if a second family comes to China, China is free to say, no, we're still holding that file for that family. And that's completely consistent with the statements from the Chinese Central Authority, which at JA 104 and what the guidance says as well, that it was never China's intention that the files would be sort of locked away just for the agencies that originally posted them. They always intended that different adoption service providers should be able to reach out to China. It also makes clear that it's China that does the locking of the file and not the adoption service provider. And that really makes sense with the structure of the Hague Convention, which vests that sort of ultimate authority over what should happen to the child in a central authority in each of the countries. And it's not sort of farmed out to these individual adoption service providers to interfere with that ability to make that determination.
Can I ask you, on the standing issue, is there additional evidence state would present at summary judgment? I'm trying to understand the district court's prejudice holding.
So the way I actually understand the district court's analysis here is entirely consistent with this court's warning in such cases as Sierra Club, in which in Sierra Club, the regular standard, and what we're looking at here isn't a question of whether the district court would have abused its discretion in letting in the declarations, it's whether it abused its discretion in not letting in the declarations. And what Sierra Club has long put folks on notice of is absent good cause, and I haven't heard anything here to say that there was actually good cause here, at the first appropriate moment in litigation where a serious question of standing has been raised, they need to put in their evidence. And as we've been discussing, that was clear from the motion to dismiss. It's always been the state's position that the guidance isn't this broad categorical ban. And then when they filed their 10, as we've been discussing, when they filed those 10 declarations, the State Department's reply brief said, no, these aren't enough for the exact reasons that we said before, and the same reasons that I'm discussing with your honors today. And then here it was simultaneous motions for summary judgment. And so again, the State Department re-raised that exact point that they didn't have standing in their opening brief, the state's opening brief. The NCFA didn't attach the replies, the additional declarations to their response to that, or to its own opening brief. It really, as a district court said, waited until the 11th hour without any explanation for why it.
Can you please answer Judge Pillar's question though? I didn't, she asked, would you have filed something in addition? I didn't get an answer to that.
I can't say sitting here today, I don't know whether or not we would have filed additional summary judgment evidence, but what I will say is
where was the prejudice?
The prejudice is that there shouldn't be sort of these like shifting declarations. So for example, Nurbas in his declaration, I can't speak to, I wasn't a trial attorney. I certainly can't get out in front of like what my client would or wouldn't do, but just myself looking at the declarations, one of the things is that Nurbas says a bunch of things about what may or may not happen in Uganda and Nigeria. And so that's something that there might or might not be evidence about.
But I know you weren't the trial attorney, Ms. Lopez, but you've seen the supplemental declarations, and it's possible that a response to those supplemental declarations would be persuasive on the standing question. It's possible that your response would be futile. And if a response would be persuasive, I would think that it's your position that you would have filed some kind of additional evidence. And if a response would be futile, then I think it's appropriate to concede that.
No, I mean, I apologize, Your Honor. I mean, I don't have a stance on exactly what evidence would or would not have been put into the record had the declarations been properly put in. Right. But what I can say is that that sort of flips the way this is all supposed to work, precisely because parties should have time to figure out what evidence makes sense to put in and to not put in. Parties aren't supposed to wait until the 11th hour to put in this new type of evidence that was entirely within their control.
Although it was a little bit irregular the way the district court handled it, in the sense that the district judge had not ruled on the 12B1 that he ultimately granted before the summary judgment briefing, but called for summary judgment briefing. And it is a fair inference for the plaintiffs to think that their explanations of how these documents affected them was sufficiently detailed and therefore did establish standing. And then when they see the arguments on the cross motion, they think, well, we better bolster this, because actually, state is taking this as a seriously still in contention, when we, for some reason, in light of the procedural handling of the case, for some reason thought was not really still disputed.
No, Your Honor, I would disagree for a couple of reasons. First, it's not as if the district court said, I have found that you have standing.
No,
It just sort
right.
of put off that decision. And second of all, because the State Department renewed its standing objection. So they knew from the State Department's opening brief that the State Department very much thought it was a live issue and still stood by everything that it said in its reply brief. And so waiting to not do that
They
in its
added it with
response
their
brief,
reply
but
brief.
to their.
If maybe I'm missing the sequence.
So sorry. So this is a
once
little
they
bit.
did that, I thought they actually, that's exactly what they were responding to.
Oh, no, Your Honor. So the case is a little bit wonky even at the motion for summary judgment stage, because they're filing simultaneous motions for summary judgment.
Right.
And so in the state's opening summary judgment brief, we renewed our standing objection. The first time after that they would have had to respond to that renewed standing objection, which certainly put them on notice that the state was sticking by what its reply brief, but they didn't do that. And certainly they could have done it at any point
Did you
after.
file a SIR reply brief to their reply brief?
No, we filed a motion to strike the declarations as untimely.
But there also you didn't say, and we want an opportunity to put in evidence. And under Rule 56D, on an opportunity to put in evidence, you in your next filing would say, hey, we really haven't fairly been able to do this.
Sure. I mean, I think our point was more the point that sort of going back to the Sierra Club case, that the way that the ordinary presumptions are that parties are supposed to put these things in to be fair to the parties opposing standing at the earliest possible moment in litigation, and that when they don't do so and they really wait till the 11th hour like this, they should be struck. I'm also happy to talk about why neither of those declarations actually get them.
What federal rule authorizes the district court to strike those declarations?
I think that's consistent with this court's jurisprudence in Sierra Club that says that parties shouldn't assume that courts would be well advised to understand that courts are not going to consider late filed affidavits absent good cause shown, and we don't think that there's good cause shown.
There's a difference between a court using its discretion to not consider a filing and a court officially striking it, and maybe it's a matter of form over substance. But just on the question of form, is there a federal rule that allows a district court to strike something that's not a pleading?
So I'm sorry, I don't have the federal rules as well memorized as I should. But for example, in the Capital Sprinkler case, that case sort of came out the opposite as this, in that it was a question about whether or not the district court abuse. I mean, and it may sort of be a sort of matter of form over substance, in that if given that the district court wouldn't have abused its discretion to not consider the declarations, and the effect of striking the declarations was that he didn't consider the declarations, it sort of comes out the same way and isn't a reason for the court to now consider those declarations or to reverse, because it would be the same decision at the end of the day.
That's good. That's helpful. I also don't have them memorized, so you're either in good company or you might not be, but you're in my company.
Ms. Lopez, if we hold that NCFA has standing, should we just go ahead and decide the notice and comment issue? There's not really any point.
Yeah, we don't, as we said in our brief, we don't, again, we don't think that there's actually standing, but because that's a legal question, we don't object to sort of, in the interest of sort of keeping the wheels of justice moving, to addressing the merits question. And I'm happy to, unless your honors want to talk about why the supplemental declarations don't get them there anyway, I'm happy to move on standing. I'm happy to move on to the sort of legislative rule questions. So here, what we know from this court's jurisprudence is that a guidance document, even one that has the effect of altering conduct or announces clearer and crisper details on how a standard like the best interest of the child standard should be understood, does not become legislative, where, as in General Motors versus Ruckelshaus, it's just reminding entities of pre-existing obligations, or as this court explained most recently in Poet, where it can be fairly drawn from those pre-existing obligations. And
but
here,
unlike in Poet, here the guidance doesn't actually purport to construe language in any statute or regulation. It talks about these type of referrals being inconsistent with existing law, but it doesn't suggest this is an interpretation of any regulation on the books.
No, Your Honor, I would disagree there. I think, they may not have parsed out individual sort of regulatory sites, but at JA 62 and JA 59, they talk about how these types of soft referrals are inconsistent with the Hague Convention and the Inter-Country Adoption Act and the regulations. And then again, at that question one that we were talking about, they were explaining that they were interpreting pre-existing regulations. And what they also do is they go back to, for example,
which pre-existing regulation?
They say that they're not announcing a new policy, but that they're actually implementing longstanding policies from the 2006 regulations.
Right.
So I agree that it's sort of not
current regulations that have been in place since 2006. I'm just wondering which ones those are.
Yes. And
I mean, which provisions are they interpreting?
Mm-hmm. So they're interpreting this as, I think, and again, these are sophisticated, regulated entities, and everybody understands, as sort of evidenced by the briefing, that what they're interpreting is the best interest of the child standard. And they're interpreting the best interest of the child standard in these two areas that are really critical. And so we talked about this briefly before, but this first thing, that of course a child's, it's so fundamental that a child has to actually be eligible for inter-country adoption in the first place before they're referred to families, that a prior debarment proceeding by the State Department said, the hearing officer there said, it boggles the mind that you would have to have something more specific than what already exists in sort of the Hague Convention and the implementing structure. And then with respect to this question of putting, and we describe that this works in terms of the holds and the interference with countries. The guidance that really has to do with suitability determination, that parents are actually suitable to adopt, is also a really important safeguard for the best interest of the child. And we know that from Article 5 of the Convention. We know that the country of origin is going to have to actually sign off on that suitability determination and have sort of the authority to decide at the end of the day what the best match is. And we know that from Article 17, for example, of the Convention. And we also know that these are incredibly important safeguards from the Inter-Country Adoption Act itself. And that's because conforming to these home study requirements is actually a minimum requirement of accreditation, and a willful violation of that standard actually is automatic substantial non-compliance. And in that context, the state fairly drew from those that where holds that are placed by the adoption service provider and not the country of origin, that prevent other families from considering those children, as the State Department describes, that can lead to longer institutionalizations, and has also led to home study agencies saying that they felt undue pressure to actually approve families, because they're essentially told it's this family or nothing. And the reason they're told it's this family or nothing is because the files are sort of being kept away from other families that might potentially be interested. And they said that they felt either undue pressure to actually say that a family was suitable when it really wasn't, or to actually entirely get out of the program. And interestingly, one of NCFA's own declarants, Armistead, said in comments that we cite in the record that she actually thought that it wasn't a good idea to allow holds in this situation at all. So it's sort of a well-documented problem. And there it's sort of fairly drawn from the fundamental way that children's best interest is safeguarded. And as plaintiff has said today, and also as to whether or not this is something that actually obviously violates the best interest of the child standard, but they have also acknowledged that there could be things that categorically so obviously violate the best interest of this child standard that you don't need a sort of more, it doesn't become something that's subject to notice and comment just because the State Department says, hey, we assume you've all been doing this correctly, but if not, this is really not okay. And then,
although the very importance of it and the confusion that we've seen ensuing would seem to suggest notice and comment would be a beneficial process here to get the input of the, and have a detailed conversation pinning down the nomenclature with the entire global community of entities that are engaged in this.
No, Your Honor. I mean, I don't think that sort of changes whether or not the State Department was actually obligated to do this through notice and comment. And also, I do just want to emphasize here that the administrative record, only some of which we've excerpted here, is 700 pages. So it's not as if the agency sort of did this as a fly-by-night thing. They were responding to emerging problems, including in its debarment, which was so serious that it was the first time that the State Department had actually taken debarment action itself, rather than the accrediting entity taking adverse action. And
Do you
so,
agree? Do you agree that adoptions in China are down 57% since this guidance began?
I don't have any reason to dispute that particular number, but there is a vast difference between causation and correlation. And so here, even before any of this guidance was issued, and I apologize, I don't remember the JA site about this, but the State Department explained that inter-country adoptions generally were down because a lot of countries were focusing on placing children domestically rather than inter-country. And then similarly, one of the reasons that the adoptions in China might be down, frankly, is because the declarants continued to mischaracterize the guidance as saying that they couldn't do these types of adoptions, even though from the March, as soon as the March guidance, that JA 5960, the State Department made sort of voluntarily injuring themselves by not participating in the program. That's not a problem that stems from the guidance itself.
You were advocating that this is just an interpretation of the best interest of the child standard, but we have been offered examples of situations in which conduct contrary to the guidance appears to be in the children's best interest. So how do you respond to that reluctance to accept your view as the State Department employee you referred to said that it boggles the mind that people wouldn't just understand this to be the case?
So, I mean, I can sort of, one, that's the State Department's position, both in this guidance and through a formal debarment proceeding. But sort of more, and that's well within its expertise, but it goes back to sort of what I was saying about the way the Hague Convention itself is structured. The very first substantive procedural step that's supposed to be taken is this determination about whether the child is even adoptable in the first place. And that makes sense because, sort of intuitively, because once a family knows about a child who, so for example, sometimes I think a hypothetical might be helpful here. So sometimes in
What
some
would
countries,
be helpful is if you wrap your argument up, you're way over time.
You can proceed and wrap it up. You can proceed.
So sorry, I'll try and be as quick as I can. So sometimes a parent who can't take care of a child for a little bit will drop the child off temporarily in an orphanage with no idea that the child might be put up for inter-country adoption. If that child who isn't eligible for inter-country adoption is matched to a family, and that one might see how the family would put undue pressure on that parent to cede their parental rights. And the Hague Convention is about safeguarding against those types of against those types of things happening. And that's why sometimes the safeguards might be a little broader, and it might like very occasionally be in the best interest of the child, but you can make categorical rules, as plaintiff has, said at argument as well.
All right.
Thank you for all the additional time.
Yeah, and we gave Mr. Hay ample additional time, and we appreciate the detailed, informative arguments on both sides. Mr. Hay, you did not have additional time, but as I mentioned, we'll give you a couple of minutes for rebuttal if you want it.
Certainly, and I'll keep this brief. So just two quick points. First, all this dispute about what declarants meant, whether how to construe it, as I think the State Department now conceded, that's not something not appropriate at this stage. But I do think if you look at what the declarant actually says, starting with Mary Moo, talking about Taiwan, the waiting children are referred to agencies for family finding efforts, but there is no document that indicates they're eligible and legally free. Ms. Sizemore similarly says that her agency stopped making these soft referrals. Were the department to rescind the soft referral ban, they would resume making them. So at a minimum, I think that the State Department has come very close to conceding that the dismissal on 12b1 grounds was improper, and that should be reversed. But we do think the court should go further and vacate on the merits. On the merits, the only thing I heard Ms. Lopez talk about is that this is consistent with the overarching goals and purpose of the intercountry adoption laws. And it may well be, we don't think it is, but it may well be. What this court says repeatedly is that consistency is not the hallmark of an interpretive rule. Many things could be consistent when an agency is using its authority delegated by Congress to choose a way to enforce the laws. That is a legislative act. That's what this court said in Catholic Health Initiatives, for example, that this sort of policy setting is a legislative act. And more broadly, the best interest standard is the North Star of adoption law. And what this court said in Mendoza is that agencies can't interpret the general mission of a statute, that specific meaning, because if they did that, there would be no reason ever to go through notice and comment. Presumably, state believes every regulation it issues is consistent with children's best interest. And if they could use that term to interpret what specific obligations they think support that interest, there would be no reason to go through notice and comment. So for these reasons, we respectfully ask the court to revert the ruling on standing and vacate the soft referral rule. Thank you very much.
Thank you both. The case is submitted.
Case number 20-5131, Protect Democracy Project, Inc., appellant versus National Security Agency. Mr. Abadi for the appellant, Ms. Haifez for the appellee.
Good morning. Mr.
Morning.
Abadi, you may proceed when you're ready.
Thank you, Your Honor. May it please the court, I'm Michael Abadi on behalf of the Protect Democracy Project. At page 78 of the joint appendix, the district court noted that it understands and shares our concern that, quote, otherwise responsive and unprotected materials may be incorporated into a document with material protected by the presidential communications privilege, thus rendering the entire document protected from disclosure. The court noted on that page at footnote 5 that it was venturing no opinion as to whether the information we seek here, which was featured in the Mueller report concerning a conversation between the president and the director of the NSA, was or was not protected by the presidential communications privilege. That is all we are asking for at this stage in the case, is for the district court to be able to make a determination about whether the information disclosed in the Mueller report as probable obstruction of justice by the president of the United States is or is not within the bounds of the
a probable what?
The Mueller report described this as the third instance of obstruction of justice by the president of the United States.
Yeah, the Mueller report also says that Admiral Rogers said that he's never been asked anything immoral or inappropriate or illegal. What do you do with that?
Well, Your Honor, we believe that demonstrates why this wasn't, in fact, an exercise of the president's Article 2 decision-making responsibility. The Mueller report did, in fact, describe this as one of the bases on which obstruction of justice could be charged, and then went on to say if Mr. Mueller could have said that no charge was appropriate and would have done so, but he couldn't.
Yeah, what did the Attorney General say?
Well, Your Honor, the Attorney General's characterization of the Mueller report is in some senses inconsistent with what the report itself says, because again, Mr. Mueller's report says, and we've cited this.
The Attorney General said there wasn't sufficient evidence to make out obstruction of justice. You say it's probable. The Mueller report didn't say that. The Attorney General refuted it. So where do you get your idea from?
Your Honor, we do believe it's highly, whether it technically qualifies as the crime of obstruction of justice, we believe it will be highly inappropriate for the President of the United States to lean on the head of an intelligence agency in order to do what clearly seemed to be a personal favor to deal with trouble of an investigation into his own administration.
We said the investigation was interfering with his foreign relations efforts with Russia. Was that proper? Was that proper for the Attorney General or for the President to make that statement to the head of national security?
Your Honor, we don't believe that the ask at issue here is proper, but I will say,
was it proper for the President of the United States to inquire of the status of the investigation when he had in mind possibly firing the FBI director?
To inquire, I'm sorry, Your Honor, to inquire of whom?
Inquire of the head of NSA, which started the Russia investigation.
Well,
when the president has the authority to fire the FBI director, correct?
The president did, in fact, fire the FBI.
But he has the authority to do that. He's head of the executive branch.
Yes, Your Honor. Again, we're not.
Does he have the authority to make inquiries that relate to whether he should keep the FBI director on board?
Your Honor, as we understand the conversation here, it was whether the president had the authority to ask the NSA director to make public statements refuting an ongoing investigation. Our argument is that this is not our argument before this court this morning, is we believe we're entitled to ask the court to take a look at that portion of the memo and determine whether it is or is not protected by the privilege. The district court did not disagree with us on the merits. It acknowledged our concern, but it said it was not going to reach that issue. And I will note the government.
Mr. Body, do you concede on appeal that at least some part of this memo is privileged?
We're not disputing the district court's finding that there are some portions of the memo that apparently relate to Article 2 functions. That is not.
And you say that this is a good vehicle to modify what you refer to as the blanket rule against segregability for presidential communications privileged documents, but I don't think you dispute that this memo really documented this one conversation. Is that right?
Well, we don't dispute, Your Honor. Of course, our knowledge of the memo has evolved greatly throughout the case. Originally, the government refused to disclose its existence. And then in the series, after it had to withdraw the Glomar claim in light of the Mueller report, it filed 2 declarations about the memo, and we persuaded the court to look at it in camera.
I understand that when the court looked at it in camera and made the comments that you referred to, but it seems that everybody's on the same page that this memo was in fact just a portion of the conversation. It's only documenting basically one interaction over Russia and the president's perception that his interactions with Russia were hobbled by what he thought was an illegitimate investigation. So I'm just not sure that I see why this is a good vehicle for probing more generally into the question whether one might, for example, have a memo that is far-ranging and covers many different topics, and the memo unit would be in some way unrelated to the material triggering the presidential communications privilege. That doesn't seem to be this case.
Well, Your Honor, we do not know, as this court has said from Vaughn on down, FOIA is a notoriously one-sided type of inquiry where we haven't seen the memo, so I can't tell you whether or not I believe the memo in camera could be segregated quite easily. I mean, it is our view that it likely could be, and we say it would elevate form over substance to say what would matter here is if Mr. Leggett wrote one memo about the conversation or 2, one memo that talked about the other aspects that the district court examined and found protected, and a separate one about the unique part of the conversation that was the most unusual thing he had seen in 40 years of government service. He could quite easily have done that, and then the government wouldn't be making the same argument. It's never made an argument about it. So we don't think it should matter whether there's one or two. But more to the point, Your Honor, this court has never considered in any of the cases talking about presidential privilege communication, the language of 552B from FOIA requiring segregability in all cases. And I don't believe it's ever had a vehicle.
We considered that. I believe we considered that in, I know we have definitely considered Judicial Watch 2, sealed case.
No, Your Honor. Sealed case was a grand jury case. So
Right.
it didn't.
Right, no FOIA, right. But
Judicial Watch 1, Your Honor, if I may, I'm sorry, I don't mean to cut you off, but Judicial Watch 1 was not about whether portions of a memo were protected or not. The question there was whether memos in a pardon attorney's office that never went to the White House.
no, I'm thinking of a case that the parties didn't cite, which is another Judicial Watch case from this court from 2005, and that's 432 Fed 3rd 366, in which the court does tee up that very language of about non-segregability and addresses it.
Well,
Basically holding that it's the nature of the privilege is in the context of a work product, not a presidential communications. But the argument is that the work product doctrine shields the materials because of the nature of the attorney's function. And the analogy here would be that the presidential communications privilege shields the materials because of the nature of the president's function. And so once you've determined that the document has that relationship to the basis for the privilege, that segregability, it's the scope of the privilege that displaces the statutory requirement, or that is commensurable with the statutory requirement of segregability. So
well, I'm sorry, Your Honor. I didn't mean to cut you off. Once again, we are not arguing here for a way to overcome the privilege. If the district court had been considering this portion of the memo and said this is covered by the privilege connected to Article 2 decision-making, this material is privileged, we wouldn't be making the argument we're making today. We're here because the court felt it couldn't do that. And
So,
FOIA requires, in all instances, in 552, that any reasonably segregable portion of a record shall be provided to any person requesting such record after deletions of portion which are exempt under the subsection.
so are you arguing that this panel, consistent with Judicial Watch 2 and in-rate sealed case, could hold that on the facts here, the district court should have conducted a segregability analysis? Or are you only preserving your argument for en banc?
Well, I would say two things, Your Honor. Although this court has said in Judicial Watch 1 and 2 that it applies to the whole document, it has never been called upon to apply that reasoning in a case. As the panel, this court could consider that and decide whether or not it is binding. Obviously, the district court here felt it was. If this court feels it is so bound as well, we would eventually be likely to ask the court en banc to reconsider that. But
and what's your argument that it's not binding?
Well, again, the court has never actually applied it. In Judicial Watch 1, the court cited in-rate sealed case, which was, again, a grand jury case. And it was describing the nature of the presidential communications privilege. And it said in passing, it applies to the whole document. It never again touches on that or applies that to the facts of that case. And in fact, if you look at in-rate sealed case, in grand jury case, the court there vacated and remanded and sent that case back to the district court for a determination on a line-by-line basis of whether need can overcome any of the privileged information.
But we do have a holding that the need is not relevant in a FOIA case.
Yeah.
I know you've argued to the contrary, but that seems pretty clear.
Well, but again, Your Honor, I'm not suggesting that's a direct application from in-rate sealed case to here. We're not asking to overcome the privilege. We're asking for the routine of applicability of FOIA segregation analysis here. And my point is, to the extent Judicial Watch relied on a case that did ultimately remand for a line-by-line, that I don't think it was a fair extension of that doctrine to say
the first instance, the first historical instance of invocation of the presidential communications privilege did not make any distinction on the segregability of any of the material that the president refused to disclose. You know who the president was?
Well, I know that the Nixon case is the first time that the Supreme Court considered.
No. George Washington withheld from Congress all the material that resulted in the Jay Treaty, and he refused to provide any of it, segregable or not.
Your Honor, again, we are not disputing that there are circumstances where the presidential communications privilege might apply broadly to an entire document. And had the district court determined that here, again, our argument would be very different right now. But we at least would have had the court consider the question of whether the specific information here, which again is so serious that it was featured in the Mueller report, whether that is in fact covered by the privilege that this court has said over and over must be construed as narrowly as is necessary only to protect legitimate Article 2 decision-making, and that there is a potential for serious abuse of this privilege to allow for the withholding of information that would show wrongdoing by high-level executive branch officials.
So, Mr. Abate, you seem to be sort of weaving together two different strands. One, the misconduct cases, and two, segregability. And is the basis for your claim of segregability is that there's reason to think that part of this memo documents potential obstruction of justice, and that to the extent that it may, that is no longer privileged. And if it is no longer privileged, then it's a distinct portion of the memo that should be segregated and released?
No, Your Honor, let me try to be as clear as I can about our position. We have a two-fold position, our primary argument and our alternate argument. Our primary argument comes directly from the text of FOIA, and it is that in all FOIA cases, regardless of the privilege, segregability is required. We think that's clear from 552, and we also believe, Your Honor, that is clear from the FOIA Improvements Act of 2016, which put an additional burden on agencies to release anything not inconsistent with the underlying exemption invoked and to take additional acts to segregate and release information.
That's your primary argument, and that seems foreclosed by precedent unless I'm missing something. And your secondary argument?
The secondary argument is that this court could recognize in a unique subset of cases that's never before been addressed by this court that segregability is allowed in the very narrow context where there's credible suggestion that non-privileged, not privileged material, but non-privileged material appearing in a document would document misconduct. This court under FOIA in various exemption contexts has grafted misconduct exceptions that allow for special rules, usually to overcome an exemption claim. We are asking for something narrower. We are saying that if there is adequate basis for believing the documents would show, and that are non-privileged and would show misconduct by high-level officials, that the normal rule of FOIA segregability, compelled by the plain language of the statute, would return. That's all we're asking for. We are not asking here for a rule that would allow us to get something the district court were to examine and say is validly covered by the privilege.
No, you're asking for something in a way that's more aggressive and that seems difficult to administer, in the sense that we wouldn't even recognize the privilege based on this court's characterization of the president's comments as potential obstruction of justice?
Well, what this court has said in numerous other cases involving misconduct and how it implicates FOIA, what numerous district courts within this circuit have said applying this court's precedent is that all that's required is a, quote, adequate basis for believing that material sought would shed light on government misconduct. And in such instances, again, under deliberative process, for example, the privilege.
Right, but that's been in the deliberative process privilege. And here we're talking about presidential communications privilege, which we know is different and more robust.
It is.
And I'm just, I mean, if it's one thing if the basis for the privilege, which here is communications about the footing on which the president is able to negotiate with another national government. If that's one part, and then if in another part of the same conversation, the president says, you know, and how are we coming with the, you know, cocaine trafficking operation out of the, you know, map room, that would be an easier call, it seems to me, to say, well, that's not an exercise of the president's Article 2 authorities. But here, the notion that the what you're referring to as the misconduct evidence within the memo versus the rest of it, it's also, you know, even granting that it's obstruction of justice, it's obstruction of justice that's intertwined with the exercise of Article 2, topically Article 2 powers. And, you know, and you can say, well, as a formal matter, once it's obstruction of justice, it's no longer a permissible Article 2. But asking us at the threshold to make that determination seems extraordinary.
Well, Your Honor, we're asking that the district court be allowed to consider whether the contents of the memo that relate to this conversation, which the government has officially disclosed through the Mueller report, which has been revealed, this is not trying to pry into some conversation that the public doesn't already know about, whether that has a nexus to an Article 2 decision-making responsibility. I want to be clear that if I answered your prior question, we are not asking that if it is obstruction, the privilege evaporates and it goes away. We are not disputing that there could be some things that we would characterize as misconduct, but are legitimately privileged and are protected. That is why what we're asking for is very different than the misconduct exception in the deliberative process privilege. We think the normal default rule in all FOIA cases should apply here, even with this privilege. If there are portions that are reasonably segregable, that do not fall within the privilege, because, for example, not every communication with the president, it's clear from this court's doctrine, is by definition always covered. It has to have some nexus to a function or a decision that is committed to the president under Article 2. If the president is having conversations that relate to normal government operations that don't call for Article 2 responsibilities, that is not within the scope of the privilege, and it has to be. There are other privileges that may protect it, deliberative process, it may be classified. There are all sorts of other ways that it might be protected. But the unique nature of this very powerful privilege is that there has to be a nexus to an Article 2 function. And here, we're simply asking for courts to be able to do what they do every day in cases that involve equally serious things, such as, information classified under national security laws, information protected by mandatory withholding statutes, like sources and methods of intelligence gathering. All of those things courts routinely deal with and conduct segregability analysis, just as FOIA argues.
All right. Do my colleagues have further questions for Mr. Abati?
Just one, if I might. With regard to presidential communications privilege, does Exemption 5 do anything that the Constitution doesn't already do?
Well, of course, this is incorporated into FOIA through Exemption 5, Your Honor. And there is no Article 2 language, for example, that compels the privilege to work in a particular way. And so Exemption 5 incorporates into FOIA the judicial and common law construction of the presidential communication privilege and allows agencies to assert that as an exemption under FOIA. I haven't heard, and I'm not aware of any authority saying that Article 2 itself compels, for example, this whole document. There may well be separation of powers concerns that motivated the recognition of the privilege. But again, this derives from common law. And the important point here is Congress, of course.
You say common law, but a statute can obviously preempt common law. Statute can't preempt constitutional law. So Is it your position that this question of presidential communications privilege is non-constitutional common law, or would you kind of concede that it's constitutional law?
We concede it has its roots in separation of powers, no question, Your Honor. But we do dispute the notion that the Constitution specifically prescribes, for example, that the entire document has to be protected versus just portions of it that bear on Article 2 responsibilities. And our view is Congress is permitted in FOIA to override it to the extent that what Congress is doing doesn't violate Article 2 directly.
Okay, that's all for me.
Thank you, Your Honor.
Judge Randolph? All right. Well, we'll give you, Mr. Abate, a couple minutes for rebuttal, and meanwhile, we'll hear from Ms. Heifetz for the government. We're not hearing you.
Good morning, Your Honors. I had contacted the clerk's office because of a phone issue, a connection issue, and was hoping to be brought in on a different line that I communicated with the deputy. Is that possible? I apologize for slowing the argument.
Yeah, let's ask. She's listening, so I think she's going to hear this.
If not, we can continue, and then I apologize.
So you would want to be brought in.
There was a 617 number, 617-794-2665.
And how does it work from your end? They call you? You don't call in?
No, I believe I have to be brought in.
Okay. So are you in a waiting room now? Did you call into the call or
no?
Not?
I am here on this phone, but was hoping to.
We can hear you. We can hear you just fine.
Yeah, you
okay,
can.
We'll continue here. I cut out, then I apologize, and then I'm sure that at that point they'll be able to bring me back in. Here, perhaps it is.
Welcome to Zoom
Okay.
Government. Please press 1 to join the meeting. This meeting is
I think that I'm back.
Yes.
Okay, wonderful. Thank you so much for your patience. I really appreciate it. It's been a morning of some technical struggles, but I very much appreciate your patience. As this court has noted this morning, this case is about a single conversation that took place between the President of the United States and the Director of the National Security Agency. And in that back and forth, as the district court stressed, was about a central set of interrelated issues related to presidential deliberations, specifically matters of foreign relations and national security, namely intelligence gathering. So I think this court has accurately characterized this morning what this back and forth looked like. It's integrated and organic nature. And as plaintiff's initial en banc petition recognized, this case really is governed by case law. Under this court's decisions, under the Supreme Court's decision, set of decisions in the Nixon cases, under this court's precedents, outside of FOIA, as well as in the FOIA cases, taking all of that together, there's nothing about the memo that takes it outside the presidential communications privilege. What plaintiff is really asking the court to do is to take a conversation where, again, the president is asking the NSA director, essentially, as the Mueller report describes, the key portion that plaintiffs are focused on, about news stories linking him with Russia and whether the NSA director can make a public statement about those. And obviously, presidents ask heads of agencies, ask White House counsel, ask OLC whether various courses of conduct are possible. And sometimes the answer is no, that something is inappropriate or even unlawful. And that's not what takes a conversation that the president himself or herself is holding with a top advisor outside the realm of the presidential communications privilege. We want the advisor to be able to answer those questions honestly, accurately, candidly, even when the answer is no, that something's unlawful or something's inappropriate or whatever the case may be.
Shafitz, let me ask you about a hypothetical. Imagine there's a 1,000-page report that does not qualify for any FOIA exemptions, including does not qualify for presidential communications privilege. And imagine that the executive branch wants to nonetheless not disclose this, they want to make sure this report is not disclosable under FOIA in the future. So they add one sentence to that 1,000-page report that clearly qualifies for the presidential communications privilege. Is it your position that the entire 1,000-page report becomes privileged?
Your Honor, the 1,000-page report, obviously many times counsel get in front of you and stress why that case is not this case. So I just want to say at the outset, obviously,
I know.
All of that is very applicable here. But no, I think, Your Honor, I don't know that a 1,000-page report is even a single record. I mean, we need to step back and
That's our other case. We have that case too.
I think that that's really an important point here. I mean, we have to recognize that there's no dispute here. The district court looked at this document in camera and understood that we're not talking about a 1,000-page report, a 500-page report, anything like that. We're talking about a single conversation between the president and the head of NSA.
I know, but Ms. Shafitz, let me interrupt you. I know that this case. It may not be my question may not be outcome determinative for this case. I think you're on awfully strong ground in this case, but I am just trying to figure out what the breadth of this very broad privilege is, understandably and justifiably broad privilege. Assume that the 1,000-page report is one record. Then if that case were before us, does the one sentence make the other 1,000 pages presidential communication privileged?
No, Your Honor, I don't even know what that would really mean. So in a 1,000-page report, we're not talking about a conversation that the president is a part of, a back and forth and organic. So that means looking more like the allegations of the plaintiff, where you're talking about something thrown in utterly by happenstance. And again, that's not this case, but that's important because I'm not sure that in that circumstance, I think we would think about whether or not the whole of the document is properly understood. And if the district court had looked at a document like that, might well have said these are separate records. This has nothing to do with the other part, or this isn't a presidential communication. There is, here.
What about where it is one record? It's one, written by one author, and it flows. So in that sense, it's in the colloquial sense, it's one record, and it's all about a conversation with the president. But part of it is about baseball, and part of it is about foreign relations. The position of the government is that the part about baseball, there's no obligation to segregate that as outside of what Article 2 and the common law developing the privilege protects.
Well, the Supreme Court in the Nixon case, for example, talks about the fact that even in idle conversation of the president, you can have casual references that are important, and nobody thinks
it's actually pretty hard to hear.
All of the president's
sound is bad. I've missed that.
In the Nixon case, is this any better?
Much
So
better.
I apologize for the visual, but as long as the audio is good. In the Nixon case, there's mention of the fact that even where you have casual reference, idle conversation, when it's the president himself talking and having a conversation with his top advisor, there's never been a case in which a court has suggested that the proper approach to determining whether the item is privileged is to go through that conversation line by line and assess whether you agree with or have concerns about a particular line. Now,
but we haven't had very many cases. So we have what you're relying on for your opposition to segregability, I gather, is the second Judicial Watch case, Loving, and the In re Sealed case, right? For the non-segregability point.
On the segregability point, I think it's important to recognize that in re Sealed case, there were materials that were entirely factual, and so the court really was confronted with the question of what is the scope of the privilege, and recognized that it did apply. In the pardon cases, you have materials that have factual material in them that are not just necessarily precise things that were being advised or about the deliberations themselves, but are all of a piece. And here we have a conversation where everything is of a piece. It's a back and forth, it's an organic discussion.
Right, that's exactly. So in the in Ray Sealed case, the back and forth was about, and that's the sort of the origin of this line that everyone, the sentence that everyone, the in their entirety phrase that the subsequent cases referred to, but that was in the context of distinguishing deliberative process, which would cover the deliberations, but not the facts, and the presidential communications process, which more akin to work product covers facts that are part and parcel of the advice giving process. That's the only issue that was before the court in Ray Sealed. Was this, is it just the deliberation, or does it include the intertwined factual material? But none of these cases, as I read them, has gone broader to say where there is material that is neither factual nor deliberative, does it nonetheless somehow fall within the presidential communications privilege?
We're not suggesting here today that purely private conversations about baseball that the president has, are clear cases that call for the application of the privilege. Again, per the Nixon case, even in idle conversation, there may be something that comes up that does, take it outside the realm of purely private conversation. And it was recognized in the grand jury proceedings cases during the Clinton administration, in connection with the Clinton administration, that no court has ever declined to treat the president's own communications as something other than presumptively privileged because of the specific topic. The president may well address personal matters within the context of official decision making. And I think the point Your Honor is making, this court has never been asked to go further afield. We're not asking the court to do that today. The nature of the conversation that's at issue in this case doesn't take us into that terrain. Plaintiff's argument, however, would take us into a very difficult place, contrary to presidential communications privilege.
Can you just hold it a little closer, because we're losing you even when it's just a few inches off. But in Ray Sealed, so what we do have here that would, I think, take us into new terrain is a different kind of claim of the relationship between the privilege and misconduct. In Ray Sealed, we defended the preservation of the presidential communication privilege, even in cases involving misconduct, by explaining that it was really important that there be communications about the misconduct so that there could be effective supervisory branch control over officials that might be abusing office. But that justification would not seem to apply in this case, where the allegation is misconduct by the president himself.
Look, we go back to the Supreme Court Nixon cases discussing the application of the privilege. The Nixon cases, we have a desire for information because we have a number of people who've been indicted, presidential assistants who've been indicted for a criminal conspiracy, and testimony about what they expect to find on those cases. And the Supreme Court never suggests, and in Ray Sealed case, Judge Wald's decision in Ray Sealed case for this court emphasizes this. The Supreme Court's discussion never suggests that means that the presidential communications privilege doesn't apply. That never means that the materials are not privileged. The question it raises is one of balancing and whether there's a need for the materials that overcomes the privilege. And what we know in FOIA is that we don't do that balancing. And that's where FOIA diverges from those cases.
Even if it were a civil case, right? If it were, we've held, even if it were a civil case, that the showing of need could trump.
Absolutely. Dellum v. Powell, yes. In civil litigation, that is certainly a possibility.
Were we wrong then?
The Treasury case.
Were we wrong to say that a FOIA case, and I know we have so said, but to say that a FOIA case can never amount to a showing of need because people are just entitled to the information as a matter the law, but why is the policy behind its civil litigation entitlement to the information?
Well, so to be fair to this court, it's not the court just saying that, it's the Supreme Court saying it in FTC versus Crowley or whatever aircraft, time and time again. I mean, this is a principle established by the Supreme Court with regard to FOIA, and it's based on the fact that the question as written by Congress for Exemption 5 is whether the materials will normally be available. And so we don't get into the analysis of need and balancing. And, you know, we're not here comparing civil litigation with FOIA and suggesting other civil litigation is stronger. It's that FOIA is a statutory construction and has these rules because it provides for broad public disclosure. In these other cases where we're dealing with grand jury subpoenas, trial subpoenas, other criminal prosecutions, or in the case of Dellum's civil litigation, we're still dealing with requests for review in camera, not necessarily limited to the court in camera.
Well, there's another answer that you're missing, which is that when there's a FOIA requester and the FOIA requester gets the information, there's no obligation for that person to even share it with another member of the public. You can take that information, tear it up, and throw it in the waste can. There's absolutely no requirement whatsoever.
That is certainly true, Your Honor. But I think here, part of the reason that there's such caution around the disclosure is because once something is disclosed under FOIA, from the government's perspective, the egg has been cracked and it's out there in the world. You can't unbreak the egg, so to speak, and material is public. Whereas in these other cases where there's a balancing going on, that's not true. It's a different approach. Look, the point really is that we're not suggesting that the privilege shields this information in all contexts. We're just talking about a FOIA request.
Right. So if my colleagues don't have further questions, I think we'll hear a brief rebuttal from Mr. Abati.
Thank you for your patience this morning, Your Honors.
No problem. Thank you for your argument.
Thank you, Your Honors, and I will attempt to be very brief. Need is not the issue that is present before the court this morning because, contrary to the government's implication, we're not arguing to overcome privileged information. That's where the need calculus comes in. We are arguing for the right to seek the release of non-privileged information in a document that happens to contain privileged information. That is the basic command of FOIA, always.
I know that you've briefed this and you've argued this at length. I'm not really sure that I follow how words the president said in the context of the interplay between his interactions with a foreign government, Russia, and the activities of domestic intelligence agencies is not at least prima facie under the presidential communications privilege.
Well, I'll try to respond as directly as I can. Not every presidential conversation is protected by this privilege under this court's case law. There has to be a nexus to Article 2 decision-making. We believe that Admiral Rogers' statements in the Mueller report show that the president wasn't making a decision about how to handle the Russia investigation.
The president was asking, can you do anything? So, and the answer I gather was no.
He was asking.
That's information that a president then uses in going forward, no? I mean, I understand, I understand your point that it wasn't just a question, it was a nudge, it was pressure, whatever, but in terms of the logic of the privilege, bracketing its propriety or not, just as a prima facie matter, to say, hey, could you go, assassinate my enemy? It's part of deliberation about how to run the country, even if it might also be criminal.
Your Honor, I tried to clarify this before. Our argument this is not privileged does not depend on whether it is or isn't misconduct. It depends on whether it is or isn't related to a decision the president must make. And I will note, again, the government has not argued at any point in this case, even though we've repeatedly briefed that the ask was outside the privilege, They've never argued it was within it. They argued other parts of the document were within it. The district court did not resolve this issue. She acknowledged our concern and said she was troubled by it, but footnote 5 at page 78 refused to decide that question. We believe we're entitled to a substantive examination of whether the ask is indeed connected, and the court reviewed it in camera. We haven't seen it, but we have serious concerns about the government's characterization, given 1, its Glomar response, and then 2, the district court's finding that it said things about the memo that were not accurate. The district court noted it was concerned with the mischaracterization of the memo. And so we believe that it is entirely appropriate for the court to be able to answer the question of whether this was not a routine discussion of what does the NSA capabilities allow us to do with foreign adversaries. The deputy director said this is the usual.
Other questions from my colleagues?
Not for me.
Nope.
All right. Thank you
Your
very
Honors.
much. The case is submitted.
This honorable court is now adjourned until Friday, March 19th at 9:30 a.m.